The views and opinions expressed on this program are not necessarily those of this station, JVC Broadcasting Management, or its sponsors.
Hi, this is Valerie Shivers, the host of Will You Trust Me, airing Saturday mornings at 11:30 a.m. We are estate planning and elder law attorneys focused on asset protection. We have offices in Sayville and in Garden City and can be reached at 631-569-4334 or on the web at shiverslg.com. I wanted to talk a little bit about the estate planning process as a whole. I know that most people, when they come into the office for the first time, don't necessarily know what to expect, what they need to bring. And I just think it's important to kind of give you a little bit of background and help you to rest assured that it is a very relaxing, easy process when you're working with us. First of all, we do offer a free consultation. So whether you're new to estate planning, whether you just want some documents reviewed that you've done in the past, or perhaps you've taken the opportunity to do these documents on your own, draft your own will, pull things off the internet, I encourage you to come into the office and let us take a look at that. So I wanted to go over 4 questions that estate planning attorneys will ask at any consultation, or at least should ask, and the reasons why we ask these questions. So first and foremost, as soon as I sit down with a client, the first question I ask is about your family. So it's a little bit of a fact-finding, getting to know you. I want to know whether you're married, whether you're single, whether you are a widow, whether you have children. I also will ask whether the children are biological, adopted, whether they're stepchildren. And I know sometimes when I ask these questions, sometimes clients don't love to say, well, this is a stepchild or this is adopted child, but it's very important for me to get down to the nitty gritty because that affects an estate plan. So what a lot of people don't realize is when you're drafting documents, if I leave a blanket statement, I'm leaving everything to my children in equal shares, and you consider your stepchildren to be actual children, which happens very often. You know, you get married, perhaps you raise your spouse's children as if they're your own from a prior marriage, and you know, you don't like to set those boundaries. You don't want to say this isn't my child. Well, in the world of estate planning, it's important that we define those terms simply because if you're leaving a will, leaving everything to your children, if you have stepchildren and they're not your biological children, well, they're going to be eliminated from your will. They're not going to be considered children for legal purposes. So if it's important to you that your children and your stepchildren are treated the same, well, then perhaps we need to specifically name those individuals. So our goal in asking you about your family is so that when we're preparing your documents, they reflect exactly what you want them to say. Another thing is, what about grandchildren? Or, you know, a lot of times clients will say, I want to name my grandchildren specifically. I want to leave them a bequest, a $5,000 bequest to my grandchild, Joseph. And while that's great, what happens if you have additional grandchildren, right? And by the way, I've seen this with wills leaving their assets to children. I once had a family member come into my office and say to me, well, you know, we prepared these documents years and years and years ago, and we left everything to the one child we had at that time, and they specifically named that child. And I said to them, well, what about your daughter? She's not reflected in any of these documents. And they didn't realize, they just kind of assumed that because they had another child, that child would be included as well. And to be honest, had the attorney drafted the documents and left it as an open class, just saying we're leaving everything to our children, that would have been the case. However, if you have a will and you know with certainty that you have names in that will, you might want to have that reviewed to make sure that all of the people, if you've had children after you drafted your will, that all of those children are recognized in your documents, of course, if that's what you want. And a lot of times that's a conversation I'll have with my clients. I'll say, well, if you anticipate having more children, or if you think your children might have more children, perhaps we leave your documents more open-ended as an open class to include those children so that we don't have to have you come into the office every single time you have a new grandchild. I'm not here to encourage you to pay for additional work for no good reason. So that's something to think about. The next question I ask my clients about is their assets. And it's not to be nosy. To be totally honest with you, our fee structure is pretty much a flat fee basis. We know what the cost is going to be if you are preparing a simple will. We know what the cost is going to be if you have a trust involved. We're not basing our fees off of your assets. To be honest, it's completely based on the workload, the amount of work. So for example, if we're creating a trust and you have one property that we're deeding into the trust, well, it's going to be one fee. If you have additional properties, most certainly it's going to cost more to deed those properties to the trust, but not because you have the properties, simply because we're actually preparing more deeds and doing more work. So when we ask you about your assets, it's not because we're nosy, it's because we're really trying to figure out what sort of planning you need. I have a lot of clients who they come in, they think they need a simple will, and then they come to realize that, well, they own a home, they have some assets, and they want to make sure those assets are protected. So knowing the level of assets, knowing whether we're talking about $100,000, a few $100,000 versus a situation where you have a home, you have life insurance, you have bank accounts, and you've accumulated quite a significant amount of wealth. Well, maybe now we're not thinking about asset protection so much. Maybe now we're very concerned about how can we avoid estate tax. So the reason we ask about your asset profile, the reason we ask how your assets are titled, are they titled jointly? Do you own your assets individually? All of these facts are very important when it comes to preparing your estate planning documents. A lot of times clients will own property, let's say a husband and wife, perhaps it's only in the husband's name. Perhaps that was done because the husband at the time was applying for a mortgage, the wife's credit didn't help that, or vice versa. Perhaps there was one property owned by one individual. Perhaps the property was acquired prior to marriage. There are a lot of reasons why people title assets the way that they do. Perhaps they're a business owner and they want to have some liability protection. If that's the case, it's very important to know that if your plan is to leave your assets to your significant other and you don't have a will in place, if you own property individually, well, that might not happen. Your children might become part owner of your real estate, and maybe that's not what you want to happen. So we will most certainly ask about your family. We will ask about your family dynamic. We will ask about titling of assets, how much you have, all because this all does matter. We'll also ask about family dynamic. We want to know, do you get along with your children? Do you get along with your spouse? If you're planning on leaving one child out of your documents, I want you to have an understanding of what sort of impact that's going to have from an estate planning standpoint. Not to say that you absolutely must have all of your children named as beneficiaries, but it's important that you understand if you are excluding someone, perhaps a will isn't the best option. Perhaps you don't want to give that child an opportunity to contest your will. Perhaps what you need is a trust to avoid probate. And there are a lot of other factors that come into play. Most certainly if a disabled child or disabled beneficiary is in the picture, we want to make sure that we address all of these factors to make sure that your estate plan is exactly what you're looking for. We want to know that we're accomplishing your goals and we're educating you. I'm okay if you come into the office and say, I want a will, and I explain to you why maybe a trust is your better option. If you're comfortable with the will, as long as you leave with education and you know exactly why you're doing what you're doing, that's all that matters to me. I'm looking to meet your goals. Again, we're going to take a break. This is Valerie Shivers. I can be reached at 631-569-4334 or on the web at shiverslg.com. Hi, this is Valerie Shivers, the host of Will You Trust Me, airing Saturday mornings at 11:30 a.m. We are estate planning and elder law attorneys focusing on asset protection. We have offices in Sayville and in Garden City and can be reached at 631-569-4334 or on the web at shiverslg.com. Before the break, I was talking about the 4 questions estate planning attorneys will ask or should ask during your consultation. And the first question we ask is about family. We got through 2 of them. We have 2 more to go, but just to kind of recap, we ask about your family. We ask whether you're married, whether you have children, whether you have a good relationship with your family. Perhaps your family is completely out of the picture and you're looking to leave assets to someone other than a child, a spouse. These are all very important facts that will affect how we plan or what sort of documents we prepare for you. We'll also ask about your assets. We'll ask, do you own property? Do you own out-of-state property? How is that property titled? Do you have a significant amount of wealth? Do you have a little bit of assets that you're looking to protect? Whatever the case may be, it's important that we get a current snapshot of your asset profile and how things are titled. The next thing we'll ask is about your distribution desires. And I have to tell you, probably one of the best parts of my job and what I enjoy most of all is really piecing together a puzzle for my clients. A lot of times clients think they know exactly what they need when they come into the office. Sometimes they don't have a clue. No matter what the case is, getting to know the client, getting to know what their long-term goals are is probably the best part of my job. And honestly, figuring out what sort of documents need to be prepared for that client in order to accomplish their goals is the end result, right? That's really what we're looking to do. So one of the questions we'll ask is, what are your goals? Why are you here? What are you looking to accomplish? Or what do you have questions about? Sometimes clients are simply looking to just put something on paper, make sure that if they pass away, they know exactly where their assets are going. Other times, they're very interested in protecting their assets. They've heard about Medicaid. They know the ramifications of not having a good estate plan in place. Other times, clients will tell me that they're just looking to make sure that the government doesn't take their assets, right? That's another big one. Other times, people will come in really not knowing what they need, and they will look to me and say, I don't know. I need a will. Whatever you think, you tell me. And education is really part of that first consultation. So when you come in, clients will say, do I need to bring anything to the meeting? Generally speaking, most of what you need, you will have in your mind. A lot of it is just fact finding and getting to know one another and making you feel comfortable knowing that we are going to be able to produce the documents you need to accomplish what you need. Another big question is rests upon, do you know who your executors, your trustees, your guardians are going to be? And that's important because a lot of times people don't realize that your executor, your trustee, your guardian, they don't have to be the same people. So just to kind of give you a brief definition of those terms, the executor is the person that you are appointing to carry out your wishes, right? The executor is someone who you name in your will, and you know that this person is going to either probate themselves or hire an attorney to help with the process and make sure that whatever you've written down and signed, whatever you have put into place is actually going to occur. That's your executor's job. The trustee is the person who's in charge of either a trust that you've established during lifetime, so a living trust, or a trustee can be overseeing funds that you've set aside for a specific reason. If you have minor beneficiaries, those minors aren't going to inherit your estate outright. They're going to be held in trust until a certain age, and the trustee is acting as a fiduciary to manage those funds during almost like a waiting period, right? Clients will say, well, if I'm leaving assets to my children, I don't want them to receive those assets outright. I want them to be managed. Can they be invested? Can they be used to purchase real estate? Can they be invested in the stock market? And the answer to those questions is absolutely. That's where your trustee comes in. So when you're choosing someone to act as trustee, you want to make sure that that person is fiscally responsible. You want to make sure that that person knows what your goals are. Are you an aggressive investor? Is real estate something that's important? Would you be willing to sell property immediately? There are a lot of discussions that should be had with the person that you're going to name or nominate as trustee. Just to tell you a quick story, when my husband and I first prepared our legal documents, we had one person listed as the executor, another person as the guardian of our children, and a trustee who was going to be, handling the funds for the kids until they reached a certain age. And we tried to be fair. We were young. We were hoping to just give everyone a job and make everyone feel important. And then over time, we started to realize that the person we named as our trustee was a spendthrift. We watched them with their own funds. They went on a ton of vacations. They spent a lot of money. They weren't big savers, and red flags went up. And while, listen, it's important to live your life the way that you want to, personally, we wanted to make sure that whoever we had in charge of funds for our children were capable of managing funds and saving and doing the right thing for our kids. And we weren't convinced that the person we nominated as trustee was going to be able to do that. So we quickly came back and kind of revised all of our documents to make sure that someone else was in that position. And we didn't necessarily have to be fair. We just had to do what was right by our kids. That leads me to the final question, the guardian. If you have minor children, have you given any thought to who you want to be raising your children if you're not able to do so for yourself? And, that's not necessarily the fiscally responsible individual, right? You can have someone taking care of your kids, making sure that their needs are being met, and someone different managing funds for them. Or, of course, you can have the same person. It really doesn't make a difference. It's really just something that you want to think about. And very often when I sit down with clients, I'll ask them these questions and they don't have the answers. So we will sit down and go through really many different scenarios to make sure that their documents reflect exactly what it is that they're looking to do. Sometimes people will say, well, I want to leave assets to this child, but they themselves aren't fiscally responsible, right? They might not be a minor child. They might be an adult child who's just not really capable of managing their own funds. that's where a trustee can step in and say, okay, well, perhaps you want to appoint someone who is going to distribute funds over time. We can set up trusts that say, I'm going to leave $2,000 to this child every single month. Your trustee can make those distributions. The trust can be discretionary. So perhaps you have provisions in your trust that say, I'm leaving everything to this person in trust. Trustee's going to be allowed to distribute $2,000 a month. However, I want to build in discretion so that, let's just say that beneficiary has a need. Perhaps they want to go to college. Perhaps they want to purchase a home, and the funds that are in trust could be very beneficial and helpful to them. Well, if you have someone who's acting as trustee who is fiscally responsible, you can say that if they feel it's in the best interest of the individual to make early distributions or to make additional distributions, we can build that into our documents. This is why it's so important for you to have an idea of what you want, what your long-term goals are for your estate plan, because it can be as simple as a simple will, leaving everything to your spouse and then your kids in equal shares, or it can be elaborate. There can be a lot of rules and regulations and really anything that you want in place. You know, it's the world is your oyster when it comes to estate planning. So I do encourage you to give us a call. This is Valerie Shivers, the host of Will You Trust Me, airing Saturday mornings at 11:30 a.m. We can be reached at 631-569-4334 or on the web at shiverslg.com. Have a great weekend.
The views and opinions expressed on this program are not necessarily those of this station, JVC Broadcasting Management, or its sponsors.